ask you a practical question. Often I find that we go into these proceedings, we don't know terribly much about the assets that are there. We're often in a situation where things have to move very quickly. What is the interaction, if any, between the court and being able to find out information about assets, for instance?
It's a very good question. And again, I would say this is where the English court strikes again in terms of its effectiveness of its arsenal of weapons. So just to put this into context, the freezing order itself, the court will make an order, either a general order that extends to all of the respondents' assets, but that's quite rare. What it often does, it will make an order to the maximum of the value of the claim, essentially. And this include interest and costs. And this is the most common type of order. But as you said, how do you know what assets the defendant or respondent has? And this is where the court's ancillary powers come in. It has a suite of powerful orders, and in particular, a disclosure order. So it requires the respondent to disclose the details of its assets. And this naturally is going to be crucial to the effectiveness of the freezing order. So the party concerned will be required to disclose all of its assets, the value, the location, the details of where they are. And as I said before, this is why it's so burdensome and onerous for the respondents. And those assets, they don't have to be just owned by that individual. They can be owned jointly. They can be held by third parties, can be in a trust, some sort of nominee arrangement, or some sort of other foundation. But so long as there is some ownership there, they will need to take steps to disclose those. And not disclosing those assets can be a contempt of court.
And is that, I take it, would there be the possibility of extraterritorial discovery then as well? So it's not limited to the bounds of where the action is located, in other words?
No, absolutely not. The court has other ancillary powers. It can include cross-examination of the respondent, passport confiscation orders, and that is extremely rare. It is, as we've said, that is a real interference of an individual's rights.
Yeah.
The appointment of a receiver, the delivery up of assets or payments into court. So a wide-ranging suite of ancillary orders.
And we do have that ability in the United States as well to discover assets. I will say, as a practical matter, and again, as a tip, it's important to be tied with investigators who really are able to produce. I think that it's difficult to find folks who can operate on such an urgent basis or operate globally. And we've had great success using investigators who are quite seamless cross-border and have the ability to obtain very reliable information. That is, to me, is a critical component to have the right investigators here to support the initial action, and then to be able to prove to the court, of course, that we have a situation of a credible danger of dissipation of assets, for instance, and the like. So that's supportive of, when you combine that with the court's powers and the orders that we're talking about here, I think that leads to the most effective global strategy, if you will. And we do have those tools available in the US market as well.
Yeah, and I entirely agree. Very recently, I was advising a client on a global strategy, and the very starting point is, do you know where the respondent's assets are? They were like, no. So the starting point is getting that inquiry agent or investigation agent to identify assets and then structure your global strategy around that. I agree.
In your jurisdiction, do you have any exceptions to an attachment order?
Yeah.
Typically, or,
yes.
Yeah. What kinds?
That's a good question. So there are certain exceptions to the prohibition on dealing, and they would normally be that the respondent may deal with assets in the ordinary and proper course of business so that their business can continue, or for ordinary living expenses, or such that they can pay their their lawyers and have legal representation. But this is where things start to get a little complicated, because subjectivity applies here and will form part of the analysis of what is in the ordinary and proper course of business, or what is considered ordinary living expenses for that individual. So, hypothetically speaking, the maintenance of, I don't know, an aircraft or a luxury yacht would not necessarily be an ordinary living expense for me, or you possibly will, but it may be for an oligarch. So, and one practical way of dealing with these exceptions is to seek the confirmation of the respondent's lawyers as to whether they consider a particular transaction to fall within one of the exceptions. And that's because as officers of the court, we have ethical obligations, we have professional obligations, and therefore you can readily rely on the representation being made by a lawyer. So that's how in practice you can enforce that.
Well, we have, again, go back to the situation in the United States of various jurisdictions will treat this differently. There was one exception in the United States that seems to rise to the top often for so many of our financial services clients, and that is that in the state of Delaware, generally the banking and insurance industries are exempt from this. So that's, as a practical matter, an appealing state for doing business, and if one wants to be free from an attachment order or have room to move within that attachment order. So that's one I just wanted to flag. I wonder, Sheila, when a claimant or plaintiff has commenced proceedings in the U.S., but the assets are located in the U.K., have you faced that situation? And are there any powers or freezing orders under those circumstances?
Yes, and I alluded to that when we were talking about the test for freezing order at the outset of this podcast. So, yes, it is a statutory power under Section 25 of the Civil Jurisdiction and Judgments Act 1982 that the English court has a jurisdiction to grant not only a domestic freezing order in support of foreign proceedings, but also a worldwide freezing order in support of those foreign proceedings. So before I talked about there having to be a substantive set of proceedings in the UK, this is when there are no local proceedings, but you have proceedings, as you say, for instance, in the US. Yeah. And it's a two-stage. Shall I take you through the
I
test,
think
Will?
that would be very helpful because I think,
Yeah.
and the reason to do so, I think, is because, again, this would be a very common use of freezing order. It would be that you've gotten and you have a cause of action, for instance, let's say New York, and it's a petition to confirm an arbitration award. You're trying to elevate it to the status of a judgment with that pending cause of action, or even if you've gotten to the stage of judgment, just freezing assets, using that as a jumping off point to freeze assets outside of the United States. So I thought, if you agreed, if that's a scenario that could happen under this, that this would be a good, just to bring it to the practical, to just walk through the steps in that
Sure.
situation.
Yeah, absolutely. So it's a two-stage test, and the second stage I will then go into more detail. But the first stage is if the facts would warrant the relief sought if the substantive proceedings were brought in England. So if the application was being made in England, would the facts warrant a freezing order? If so, then the second question arises is whether it would be inexpedient to grant the interim relief sought, and that is specifically provided in the statute. So what does this really mean? The relief must be sought in respect of civil proceedings, so it has to be civil, but I think that's what we're talking about. We've already talked about the test of good arguable case. So, Will, that's interesting. We've got foreign proceedings, yet we still have that slightly lower threshold of good arguable case. There must be a real risk of dissipation, and we've spoken about that.
Mm-hmm.
And then it must not be inexpedient. And going back to that point, what does that really mean? It means there has to be some proximity to England. If there are no assets in England, if there is no allegiance to England in any way, if the respondent is not domiciled here, and therefore there is absolutely no connection to England, the court is not going to exercise its jurisdiction. There could be an agent. There could be, in fact, there is a case, a Court of Appeal case, where proximity to England was determined in circumstances where the individual had legal representation in the UK. So it doesn't necessarily rely on assets or being domiciled here, but there has to be some sort of connection. Where the court cannot enforce the order if disobeyed, it won't make the order. And I think that is connected with the proximity to England point I just made. it won't make an order where the making of the order will interfere with the management of the case in the primary court. Here you said in New York, for instance,
Mm-hmm.
or where there is some sort of disharmony if the order is made. So where you've got two different
So
orders which clash.
deference from that
Exactly.
to the
Exactly.
in that instance the U.S. court. So
Yeah,
yeah.
exactly. So the hurdle is high, naturally, but it is a very powerful tool and one which many claimants do come to the English courts for.
And
And
yeah, I'm sorry, please.
no, I was going to say, do you have specific examples where a party has sought to go to come to England or actually another court in the US?
Yeah, and I was thinking of it again. You and I like to bring things to the concrete. So, in terms of native arbitration, I was thinking of we had a case in 2021, which was on behalf of Telecom, not our firm personally, but in the U.S. Telecom, and it was against IBL Bank, and this was an award that came out in the Lebanese Arbitration Center. So the award was 97 million US, and there was a petition for confirmation of that in the Southern District of New York, which is, as you know, a very common place to bring such confirmation proceedings of an arbitration award. And when they sought to confirm the arbitration award, they did seek an attachment of 100 million US as well. And while that amount ultimately was reduced sharply, it was granted in support of that arbitration award. And talk about a powerful tool. The issue in that case was ultimately what discretion does a U.S. court have to reduce an attachment in a situation like that? There were arguments that given the size of the award, that would actually have an impact on the Lebanese economy, that there were other significant potential hardships there. And so the party was able to reduce the attachment, as I say, sharply. Ultimately, though, that what was interesting to me, Sheena, about that case is that the court said that the trial judge has a lot of discretion, and it wasn't outright, not at all, barred from issuing such an extensive attachment order. It was a question of allowing that court to take into other factors what potential hardships there might be. But I do think that there's language in that decision that talks about how much authority a court has to put in this very powerful attachment.
Yeah.
I say powerful as a tool for ensuring that your arbitration award and judgment will be satisfied. And I do think that it really does come down to that. As we've said, we're talking about these not just in some sort of vacuum about what is a freezing order. We're talking about it in the context of the overall global asset recovery strategy. And I do believe that is this is a critical component, but that we also have to take into account all the other potential tools as well. What are your views?
I entirely agree. It is so critical at the outset to look at it, as I said before, holistically, and to work with other lawyers around the world where relevant to ensure that what you have is a really credible legal strategy that you can take forward and which is flexible and can change, as I said before. Parties don't take a linear pattern, do they? Pathway. They will chop and change, and especially a defendant or respondent who may start off a set of proceedings feeling quite robust about their defense, but as those proceedings continue and the claimant is sort of hitting them with a stick, they feel more and more vulnerable, and especially when a judgment or award is pending and that their behaviour may change. So it's always to remain flexible and to consider other strategies as you progress.
Well, let's keep the conversation going, and we do thank you for joining us on this latest edition of Eversheds Sutherland's podcast, and hope that you'll continue the conversation with us.